We're at page 410 of the text. To get started with civil litigation, notice on the lower left corner you can see the page number. You could bookmark this page. And notice you can get rid of page numbers over here. Then you can't see them or get them back. Ask for help from me or from support if you can't get your page numbers, of course. But they have some very simple sample questions for what they call voir dire. There's two ways we use voir dire during a trial, but one of them is to ask questions called preliminary questions of the jury panel, the people that might be picked to be on the actual jury. And you want to be able to come up with more questions than that, of course, and they're being asked about a cancer case and so on. But try to ask questions that could relate to possibly being biased on our case. We're using the same case as last week. And of course, we are still on Mr. Bob, Mr. William Bob, or Billy Bob, however you want to say his name, against Widget World. So you don't want people who are totally unsympathetic to the employees of this world. I've been self-employed. I still certainly would not be unfair to people who were employees who had difficulties, who needed to go on workers' compensation or something like that. But some people would, and just asking simple questions about people's work experience, self-employment experience, whether they've worked in the corporate world, what capacity. You can ask various questions about that. I would try to get jurors to talk a little bit rather than ask them questions that they can answer with a flat yes or no, although yes or no questions are sometimes allowed. You know, I shouldn't say allowed. Of course they're allowed, but in terms of being the best questions, they are frequently not the best question. It might be better if the question asks them to tell something about their work experience rather than to just ask them if they've had a job. Have you had a job? Yes. Well, that doesn't really get us anywhere, does it? Now, you do have some juror information sheets. You want to summarize the information, but you also want to talk about what you might check with the jury, number 2. Number 3, 10 questions. And it says if the question is a yes or no question, you should include follow-up questions. And like I said, I'd focus on trying to ask ones that are not yes or no. Who, what, when, where, why, how, and use those. They don't have to all be about the case. You really are not supposed to let the lawyers coach the juries about this very specific of the case, but they can be asked about the type of matter, about employer-employee things, and they can be asked about their thoughts about those things and whether they can be fair to both sides and things like that. Note in the discussion that not every piece of evidence is allowable at trial. Some pieces of evidence are just too prejudicial that they outweigh any possibility of their usefulness. So think about objections. Lots of evidence is not allowed. Why isn't it allowed? Rules of evidence would help the most. So you can definitely go to rules of evidence. One of the best ways is just simple ways just to go to federal rules of evidence. Federal rules annotated over here under federal. You can get at it through a question or just through table of contents, of course. Once you're there, you can go to the table of contents here. Remedial measures. The fact that somebody fixed something is not necessarily usable in court. Why? Because there's a public policy that people do fix things, and we don't want to punish them in court for having fixed things. I think you learned a little bit about the fact that compromise offers are not going to be usable in court, and various other things. Just go through the table of contents. So we take a peek at the PowerPoint. Remember, recordings can make you feel daffy. Listening to recordings while multitasking is not working, so it helps to listen up. Take a look at the citations. I'm still not getting everybody to use citations. Some people are using them in discussions but not in written assignments, or using them in written assignments, not discussions, or if they're doing a reference page, they're not doing multiple in-text. You need to do multiple ones of these, of the in-text. So do multiple ones of these. And then do one for each source on the reference page. And that's it. Don't forget the objectives, preparing data sheets, voir dire questions, which are helpful. And here's tips. Really work on reading and rereading every word of the lesson notes, notes and type questions as you do the work in the text, quotes and cites. The written assignment, work on text and other information about jury selection. Open-ended questions. In the discussion, share research methods and rules of evidence. Basic criteria. You want to summarize the potential jurors. So you're summarizing, and then list additional research you would do for each specific juror. Would you check the LinkedIn page? What else would you look for? What do you want to get out of it? Create a list of 10 separate questions you might want to ask jurors during voir dire. Here's the live lecture quiz phrase, which is incompetent, irrelevant, and immaterial. To get to the emerging level, which is the basic level, starter level, if you summarize potential jurors for possible tendencies and general characteristics, but not with much specificity, you can get 6 out of 10 points. Some additional questions are prepared, you get another 6. research investigation plan 6, so on. But you need to proofread more, of course, and do more. And then to get to the competency level, you have some more specificity. You can get another point. Additional questions, research investigation plan, you just do a little more. And then, of course, to get to the proficiency level, be thorough. Additional questions are helpful and show comments. So if you're not sure what questions to ask, take a try at it and then ask questions about the questions. Why might this work? Why might it not be workable? Be as well thought out and thorough with your research and investigation plan as you can. And then grammar, spelling, word usage. And I caution you, it doesn't necessarily mean that you are doing a perfect job with grammar, just that you get 5 points. You submitted enough correct content to get the points. When you're pretty good at grammar, make sure, or whether you're not good, use GrammarBook. Use grammarbook.com, and you're going to find out that even if you're quite good at grammar, you can learn more. Instead of having to say, oh, it just sounds wrong, you can say inconsistent verb tense, passive verbs and abstract nouns don't work here. Things like that, that not only make you seem smart and very, very competent, but you become the go-to person at the law office for proofreading, and you are the person that they consider somebody that they definitely need, put it that way. Text pages that are key. You want to take a look at certain text pages. One of them is just to know what we're doing and why we're doing it. How would we do it in real life? And yes, you would very frequently do a little map of the jury box. Now, and I wouldn't do 12. I would do at least 14 or 16 of those, depending on what the lawyer says, how many people are put into the jury box area during the questioning. Usually often more than 12, even if it's a small jury being picked, you'd have that many people sitting down before they're started. And then, of course, being able to know who got asked which question, but you don't necessarily know ahead of time who's going to be picked, of course. So you can be there with the lawyer and assist and make sure you get the right name in the right box, so he or she knows who they're asking. But think about the difference between a challenge for cause, which means that they're definitely biased, or the peremptory challenge where we think they might be biased for the other side. So we do get to ask questions about actual bias, but we also get to ask questions that indicate just a possibility that they may lean one way, even though they're trying to be very fair. You can ask me about text pages that help. Minnesota Civil Practice would be an example of something that would help for trial preparation. More things to know. Access rules of evidence in your state. In Lexis, go to rules of evidence and federal rules. I showed you some of those, 403, 405, 401, and others. And that's all we're going to talk about right now. Thanks for listening.